Good evening. I'm Rakesh Ranjan, a student of LL.M 4th semester at the Central University of Haryana. And today I'm here to present on a very important case, a critical appraisal of the prosecutor versus Jean Paul Akayesu case. This is a very important case, and as in the course of presentation we will see the importance of this case as per the international human rights and enforcement of international human rights is concerned. The next slide, where I have tried to summarize the case, where in this case an international tribunal was formed to prosecute the criminals of Rwanda genocide, something we will see in the slide later on. The accused in this case was Jean Paul Akayesu, who was something equivalent to mayor in the city of Rwanda. The ICTR tribunal that was formed found him guilty on 9 counts of genocide and numerous other crimes against humanity and many other types of crimes. After being convicted by the trial chamber of ICTR, he appealed to the appeals chamber, and actually the appeal was made by both the parties, and appeal chamber gave his judgment, and on 14th of December the appeal chamber corrected his judgment due to some problems into the initial judgment. So this is the summary of this case, something we will see in the next slide. I have tried to discuss the Rwandan genocide that has happened. The Rwanda genocide, as many of you we must be knowing, it actually continued for around 100 days, even something near 100 days. Actually, it was an ethnic conflict between the Tutsi minority and the Hutu. The Tutsi and Hutu are two ethnic groups in Rwanda. They were having some sort of civil war and some using the neighboring country's territory to launch some civil war. Out of a sudden, the propaganda that was going on, because the government was in the control of Hutu, who was a majority. So they all of a sudden started attacking the Tutsi minority ethnic group and many other ethnic groups also, and it is being estimated that some 5 lakh to 8 lakh Tutsis were butchered, and the biggest part was that more than 2,50,000 to 5 lakh women were raped during this genocide. Here I have tried to take one picture that was available, and in this picture we can see these are the skeletons of the Rwandan genocide victims that has been made on display after the brutal genocide that happened. So the entire case that was based on the Rwandan genocide. So this was a summary of Rwanda genocide, and now we will proceed to the next slide, where we will discuss the International Criminal Tribunal for Rwanda. The case that we are going to discuss was actually a judgment that was given by this International Criminal Tribunal for Rwanda. This special criminal tribunal for Rwanda was formed again after the Rwandan genocide, an international court established in November 1994 by the United Nations Security Council. This was after a Security Council Resolution 955, which established this international court in order to judge the people who were responsible for the Rwandan genocide. If we try to talk about the classification of this tribunal, we will have to understand that this tribunal consisted of 16 judges who were divided in 4 chambers. 3 of those chambers were to hear trials and 1 was to hear the appeals. The first trial began in 1997, and this is a most important thing, that the Jean Paul Akayesu, the case which we are going to discuss in this video today, the first trial that began under the International Crime Tribunal for Rwanda was of the Jean Paul Akayesu. And after the first trial began of Jean Paul Akayesu, the ICTR has till now indicted a total of 96 individuals. This tribunal, although it has already convicted and indicted a large number of individuals, so the tribunal has been officially closed as of now on 31 December 2016. The new ICMRT is the new successor of ICTR, where International Residual Mechanism for Criminal Tribunals, this is the full form of ICMRT, and this new criminal tribunal has been formed to take up the residual cases that are remaining there after the ICTR has been disbanded. Now we will move to the next slide. Just one of the current affairs that I have got while studying for this project, that the quest for justice continues. Just a few days ago, what I was seeing in the news, the few days ago on 24th May 2023, a fugitive Fulgens Kayasima was arrested from South Africa. He was alleged to orchestrated somewhere 2,000 plus Tutsi refugees when they were taking shelter in a Nyanseng Catholic church. you can understand the achievement and the thing that was there after his arrest. UN Secretary General himself commented on his arrest and told that it sends a powerful message, and however important and however influential and where are you hiding, you will be punished. And the important thing is, after him only 3 more fugitive remains to be brought to justice. So a tribunal that was formed for the justice to be given to Rwandan genocide victims, it remains a matter of extremely satisfaction that till now, of all the people who were charged by the Rwandan tribunal, after the arrest of this person Fugulence Kayasima, only 3 of them more are remaining to be brought in justice, and rest all of them has been brought to justice and they have been either convicted, at least they has been charged. This is one of the news article that has been published by the United Nations News that has announced the arrest of top Rwandan genocide fugitive. And now we will move to the next slide of the case. About this case is about the accused in this case is Jean Paul Akayesu. Jean Paul Akayesu was the mayor of a Taba commune in Gitarama prefecture from April 1993 until 1994 when the Rwandan genocide was happening. He was having the de facto control of the police, and he was later accused and of course convicted of targeting and supervising the genocide of Tutsis in his jurisdiction area. After the Rwandan genocide had ended and the international pressure started to get up, he actually flew away from Rwanda and went to Zambia, and he was arrested from Zambia to stand trial in ICTR for his crimes against humanity. And as of now, he has been given life imprisonment, and after being declared guilty, he is now serving his life imprisonment in prison. And one more thing that was interesting, that when the Rwandan genocide was happening, although after the Rwandan genocide happened, there was international tribunal was made and all those things, but when it was happening, no major country actually came to protect the minority people from the genocide that were perpetrating. One of the incident when the United States was the official spokesperson to the United States State Department was asked that whether a genocide was going on in Rwanda, they actually refused to recognize it as a genocide, because recognizing it as genocide would have meant that United States will have to send their own armed forces to the ground. So at that moment when it was happening, no one even recognized that a genocide was happened, and as a result hundreds of thousands of people were killed. Now we will come to so this is the identity, and this is the introduction of the accused in this case, Jean Paul Akayesu. So now we will move to the next slide. This is about the proceedings at the trial chamber 1. This case, as I have mentioned earlier in this project, that in the Rwandan genocide there is a trial chamber and there is an appeal chamber. So this case was first heard at the trial chamber, where the prosecution actually charged Mr. Jean on 15 grounds that included genocide, rape, crime against humanity and other things. And the defense that was taken by Mr. Jean and his defense counsel, that he was a very small person and he was powerless to stop it, and he is being made a scapegoat for the mistake of the people of the city at that time. However, there is a conflict in his statement that there was one individual, a journalist, who was charged to gather evidence against Mr. Jean. All of a sudden, his husband and his daughter were killed by unknown persons when she was going to collect the evidence. So this shows the influence that this person had. However, his argument was that he was too powerless to stop it, and no one understood it. Despite his arguments, the trial court declared him guilty on 9 counts. So he was discharged on 6 grounds, and he was given different type of punishment, but ultimately after summing up all the punishment, and all those punishments were to run concurrently, so after summing up all the punishment, he was given the life imprisonment. In this case, the court freed him of Article 3 of Geneva Convention, war crimes, that he was charged in that. However, that was challenged later on, and we will see it in the judgment of appeals chamber. So this was the proceeding at the trial chamber, where he was given life imprisonment, but he was also discharged in some of the grounds, and some issues of law actually came up on the ground. So both Mr. Jean, who was given life imprisonment, the prosecution, both of them went to appeal chamber, and on their grounds they challenged this judgment of trial chamber into the appeals chamber. So we will now move to the next slide. The appeal made as per the provision of ICTR. So appeal chamber is officially organization of International Crime Tribunal, ICTR. That was it is totally constitutional. So after the trial decision, both the parties came to appeal, and The arguments of prosecutor was focused on the judgment of trial court that freed Jean on the charges of restricting the application of Common Article 3 of the Geneva Convention to a certain category of persons. So we will see it later on in detail. The accused appealed on 11 grounds. The Mr. Jean appealed on 11 grounds, where he actually challenged the entire proceeding that has convicted him, and he challenged the sentence also. The appeal court, after hearing all the arguments from both the sides, gave its decision. And now we will move to the next slide. First of all, we will talk the appeal arguments by the accused Mr. Jean. The first thing, he denied the right to be defended by the counsel of his choice. He wanted to be there has been many instances in the appeal court judgment, it has actually been written by the judge that he was not being allowed to be defended by a counsel of choice, because there is no international compensation. You have a right to be defended by a lawyer, but this right does not include that you have to be defended by this lawyer only. So this was, and his behavior also was not so much good. However, that was cooperative, and many a times in the trial when he actually demanded change of the counsel to him. The second argument, that he told that denial of the right of a competent counsel. So he appealed that a competent counsel was not given to him. Second thing, he challenged the entire partiality of the tribunal and told that it is a biased and partisan tribunal. Next thing, he told that there was a total absence of rule of law at that time in Rwanda, and for the crimes that was happening, it was a collective crime done by collective persons, and he cannot be held responsible for their crimes, and he was just a small pawn there. The next thing was improper hearsay evidence. So the evidence that were used in his prosecution were hearsay as per him. There was irregularities in examination and cross-examination. There was unlawful disclosure of defense witness statement, unlawful detention that was happening of him due to the entire proceeding. He had challenged the entire proceeding, so the detention that was happening was unlawful, and he actually also appealed against the sentencing judgment. So these were around some 10-11 grounds on which he actually challenged the entire trial chamber's judgment that was given. He challenged their entire process, entire conditions, and the sentence that was given to him. And the next, the prosecution's ground of appeal were actually, there were 4 grounds of appeal by the prosecution. The first and second ground of appeal was against the Article 4 of the statute, that was the ICTR statute that formed this tribunal, where they told that it is a violation of Geneva Conventions and of additional protocol. And in this, the trial court have taken the defense, while acquitting Mr. Jean, has taken the defense that public agent or government representative test. This test was imposed, so the prosecution challenged in the appeal court that this test cannot be applied here. So the third ground of appeal was Article 3 of the statute, crimes against humanity, whether the discriminatory intent should be when you are doing the crime against humanity, or it should not be there. This was the ground that was challenged there. And the fourth ground of appeal was Article 6(1) of the statute, where the intervention of the person who is being accused of doing a crime, either this intervention should be direct or public, or if there is a sizable evidence that there was a intervention of the person, although he did it smartly or by hiding, then he cannot be prosecuted. So all these 4 things were challenged by the prosecution. These were the matter of law that were challenged by the by the prosecution against the judgment of trial chamber. The legal questions that were raised in appeal chamber, that whether these were the legal questions, whether the issues raised by prosecution in its appeal were to interest to the legal practice of tribunal and had a nexus with present case. Right to free of legal assistance confers the right of one on choosing, that I have discussed before when I was discussing the arguments and accusations of Mr. Jean, and when he was filing the appeal, when the accused demonstrated gross incompetence of his counsel resulting in miscarriage of justice, hearsay evidence. So all these things, point of law, error in point of law, discriminatory intent that was filed by the prosecutors, incitement as said in section 6(1), and the effort of the sentence be in case of ground appeal, when something has been appealed, what will be the effect on the sentence. So all these legal questions appeared in the judgment of appeals chamber that were to be decided by the appeal chamber. So now we'll move to the next slide. The specific legal rules and provisions that were there in the question was the Article 3 of Common Geneva Convention, 342E of Additional Protocol 2, and Article 1, 2, 3, 4, 5, 6, 1, 3, 12, subclause 1, 15, 17, subclause 1, 19, subclause 1, 20, 23, 24 of the ICTR statute, the statute which actually authorized and formed the tribunal for the Rwandan genocide people, and the rules that were there. So these were the important provisions that were referred to while having the appeals case in this. And now we'll come to the judgment of the appeal court. The appeal court heard it in detail and gave his judgment. In the judgment, it dismissed all the appeal points raised by the accused Jean Paul Akayesu and upheld the judgment of trial chamber. So there was no relief given to the accused on grounds of the arguments that were raised for it. And if you read the judgment here, there is a detailed, some 70-80 pages has been written to give arguments that why all of the charges by Mr. Jean has been dismissed. But the question of law that was raised by prosecution was also dealt in this judgment. The first two grounds of appeal that appeal chamber found that trial chamber actually erred in restricting the application of Common Article 3 of Geneva Convention to certain category of person. The certain category of person, if you read the Article 3 of Geneva Conventions and Additional Protocol were actually made to stop the violence and to restrict the violence and to make certain persons who were responsible for violence in an armed conflict situation. So the trial court was unsure about that whether you can use that provisions of Geneva Convention that were formed during the article that were formed during the war purpose. You can use it in a genocide where there was no active war. It was a violence that has happened. So trial court thought that they could not implement it, but in this court the judgment was given that Article 3 of the Geneva Convention, the definition that has given, it can't be applied to the restrictions of ICTR because the ICTR restrictions has to be wide. The humanitarian law will lose, it will be poor if the limited scope is being given. The trial chamber decision was limiting the scope of the humanitarian law because it was restricting the people who can be punished for the crimes that they have committed, because then you will have to, if the trial chamber has its way, then only when a military war is going on and then genocide happens, then only it can be charged. So it would have limited the scope. So the court appeals chamber expanded the scope. The next thing was second was issued. The third ground of appeal was when appeal chamber clarified that Article 3 of the statute does not require that all crimes against humanity humiliated there must be committed with a discriminatory intent, and that said the article restricts the tribunal jurisdiction to crimes committed as part of widespread or systematic attack against civilian population or discriminatory. Here also the court gave its judgment, and then on the fourth ground of appeal, it was clearly said by the appeal chamber that under the 6(1) of the statute, if there is an incitement, it need not to be direct and public. You can't act smart, you incite the people while hiding while remain yourself into hiding, and then you can bypass the judicial system telling that, oh, I was not there at the present. So the appeal chamber made it clear that if you incite a violence, then you will be held responsible for that. In that, it also overturned the judgment of the trial chamber, which court said that it should be direct and public. So this was the entire judgment of the appeal court in this case, and now we will move to the next slide. The corrigendum that was given in this judgment on the 14th of June 2001, that is very important to in the case Prosecutor versus Jean Paul Akayesu. This corrigendum was issued, and this corrigendum was issued only because there has been some mistakes that had happened while the final judgment was given by the appeals chamber on 1 June 2001. This corrigendum was issued by the appeal chamber on 14 June 2001. The corrigendum consists of total 6 pages in total, and it made certain corrections in the judgment. Now we'll see what were the corrections. I have just put the first page of that corrigendum of the appeals chamber that was given on 14th June 2001. The name of the judges and other things were the same. Here now we will now move to the next topic, next slide. Here about the issues in corrigendum. The original judgment that was given on 1 June 2001, the name of Mr. R. Marcin was not included in the certified copy. this entire collegium was issued when the name of Mr. Murthy was not there in the judgment. So the court ordered that the name of Mr. R. Murthy Marsuan name should also be included in the judgment, so as to give full and due credit to him as the list of counsel for the office of prosecutor. The court also ordered that his name should appear in all the copies of judgment and all its translation, and in case of any conflict between English and French law, the French version will be considered authoritative. So this was the 6th page, and then there were certain other pages that gave implementation. So this was the brief judgment that was given on 14th of June by the Appeals Chamber Court in this case. So now we will move to the critical appraisal of the case. The case that I have heard, first of all, it was a very historic step to start the process of having accountability for the Rwandan genocide, and it was a very interesting and very clear phase that in front of the challenges that international community faced to stop these type of genocide, the step that was taken, and as in the previous slide I was informing that there are only 4 people who were remaining, who are now remaining, who have been charged but who are remaining to be sent into jail, and one of them has been arrested just a few days back. So I have I have shown it in my slide. So there are now only 3 persons that are still remaining to be given punishment. So this gives a very good picture of the efforts that has been put forward by the International Crime Tribunal for Rwanda genocide, where they prosecuted all those people who have been charged. However, the appeal court, when you see the judgment, the appeal court should have considered the request. This is my personal opinion. Appeal court should have considered the request to have accused an attorney of their own choice, although it is not legal necessary. I mean, if they have been the accused, Mr. Jean, he has done the crime, so he is going to be punished. But if he wants someone to defend him, the court should have given, because if the justice is done, some secretively, or there are some loopholes that are remaining, it may, act as a festing ground where things may worsen in the past, like we have seen when the Saddam Hussein was dethroned by the American forces in a military coup, where in the attack. So even though the new government came to Iraq and everything was stabilized, the majority Shia community got power and democracy came and all those things, but still the Islamic State came into forefront because of the anger that was there in the Sunni minority in the Iraq. So these type of activities, although the crime that has been committed by the majority ethnic group in Rwanda actually were very grave, but still nothing should have been allowed by the international community to give any benefit of doubt to these criminals. So even if an attorney of their choice has been given, it would not have a big deal. There were accusations that certain leaks were done, although it regularly happens in a democracy, but still to ensure the highest standard of justice, it could have been ensured that no this type of leak happening. The ICTR also has been criticized in general for its failure to bring Rwanda Patriotic Front (RPF) and its leader Paul Kagame to justice. It was also a fact that although this genocide was against the Tutsi minority, but still there was a Rwanda Patriotic Front which also have done the war crimes, and its leader Paul Kagame has also played a part in this. But the International Crime Tribunal actually focused on only one side, and has been severely criticized that it failed to serve justice in a completely unequitable manner. So this was the critical appraisal of this case, and now we will move to the last topic. So I thank you, all of you, for your kind patience for watching this video and learning from watching this video and hearing me. It has been a good experience for me also. And if there are any such questions, you can put down here in this video, and I will try my best to answer it. And I would also like to thank my teacher Rakesh Meena sir, who have given me this opportunity and who have provided us this case and given me this opportunity to present this case. बहुत बहुत धन्यवाद. नमस्कार.